You're listening to the Today's Wills and Probate podcast, one of the leading sources of information for the wills and probate sector. Don't forget to subscribe and sign up to our free newsletter at todayswillsandprobate.co.uk and follow us on LinkedIn and Twitter.
Hello, welcome along to the latest Today's Wills and Probate podcast. Today I'm chatting with the founder and CEO of BePrepared, Dylan O'Brien. Dylan's going to explain a little bit more about who and what BePrepared is, but it's great to have you on the podcast, Dylan. Thanks very much indeed for joining.
Thank you so much for having me, David.
Topic today, and listeners with an acute ear will hear that you're not from these shores, Dylan, is technology. It's about the way in which lawyers are struggling to adopt technology. We're talking at a time when even legal services is almost taking a step backwards with the move to not continue with online will witnessing as an example. So I'm looking forward to this one. But in the first instance, would you tell us a little bit about yourself, please, Dylan, and a bit about BePrepared as well?
Yeah, of course. So my name's Dylan. Founded BePrepared too many years ago now. And BePrepared gives estate planners and law firms an instant solution for handling their clients' digital assets. Digital assets are not just cryptocurrency and NFTs. It's everything from the PIN to your phone, your password, your email accounts. So we give firms the ability to manage their clients' digital assets, part of an estate plan, while also just saving them hundreds of hours per year on email, automating the client referral process, and really making them stand out amongst their competitors.
A useful introduction. The question that always comes to mind, and hopefully you get this on a regular basis, Today's Wills and Probate also has a sister publication, Today's Conveyancer, and in that publication at the moment, there's a lot of talk about property logbooks, digital resources and digital vaults almost that kind of hold property information. And the question I asked them, and the question I'm going to throw to you is, what's the difference between what you're doing and something like a Google Drive, a Dropbox? You know, it sounds to me as an outsider looking in that some of this stuff is very similar, but you may well tell me differently.
I do get the question a lot. Somewhat coincidentally, a lot of firms use our vault for their property documents and conveyance documents and things like that also. Fundamentally, that there's two core differences between what we do and what a Google Drive would do. So the first one is our platform is designed to store stuff securely. We are fundamentally a cybersecurity company. So when you look at a Dropbox or a Google Drive, those platforms are really designed to share information. They're designed to make it accessible wherever you can, share it to people, share it across things, etc. BePrepared is designed to keep your highly sensitive and secure information secure and make sure that no one can see it until after you die. And that leads me to the second difference between us and a Google Drive, for example. Nothing against Google Drive, of course. When you die, your stuff is inaccessible. So there have been cases against Dropbox, there's of course cases against Google Drive, and more recently Google Drive has adjusted their terms and conditions to delete your data after 2 years of not being accessed. So let's say you lost capacity and you couldn't access your Google Drive. By the time you did pass away, or by the time one of your attorneys or guardians wanted to access any of that information, it'd likely be deleted. What BePrepared does is when you do pass away, it makes that important data accessible to your executors or your attorneys to help administer your estate efficiently and effectively. So an example might be you have all your receipts and invoices and pretty much anything you buy these days goes into your email account. What used to happen is when you passed away, you could divert the snail mail and reasonably be assured that you've kind of catch everything within a couple of months that's coming in. Nowadays, when someone passes away, there are instances of people just not finding out about properties, about subscriptions, about online gambling accounts or trading platforms or share platforms that they just simply didn't know the client had until years later when something pops up somewhere randomly. A lot of lawyers are trying to go through bank statements, trying to find references to things like that, but it's a real kerfuffle. And so what BePrepared does is allow, when you pass away, the advisor, your executors or your attorney, get a list of all your digital assets. They get access to your accounts, your phone, your computer, and they can save up. Some of our clients report saving 9 months on estate administration just because it's all there. They can get probate straight away. They can go administer your estate, and it's tied up neatly and effectively, and really reduces the suffering on your loved ones.
In England and Wales, the Law Commission are currently looking into what constitutes digital assets and
Yes.
understanding how they can be transmitted through end-of-life planning, will, or whatever it might be. I said that listeners would probably hear that you're not from these shores. You're an Australian. Is the Australian market a step ahead in that sense then? Have you understood what digital assets are, codified them, and are you better at transmitting them?
No, not at all. So kind of globally, there's this interesting tug of war that happens because organizations like STEP, which we're a part of, and kind of these global bodies look at wills and estates, kind of push these technology companies to provide solutions for your executors. But those companies have very little motivation to do anything because you're not paying them after you've passed away. They're focused on their competition. They're focused on growth, getting more users, making more products. And then on the flip side, they kind of have to worry about their own privacy statements, their own users' terms and conditions. And so, for example, we were talking about Google Drive before. So Google Drive has an inactive account manager, and you can elect someone in your Google Drive to receive information after you pass away. But they only give you some of the stuff. They don't give you everything. And it's similar with iCloud. iCloud has a legacy contact. And again, you can get access to photos, but you're not getting access to passwords. And so what kind of happens is you got the tech companies not really dealing with it. There's no real solution for people, your executors on their end. You can't do it retroactively. After someone dies, you can't grant them access, especially with the way that encryption and security is going. Like currently, it's a big global thing that everyone's worrying about. Quantum computers being able to crack a modern day encryption. They're worried about AI being able to crack a modern day encryption. Cyber threats are at an all-time high. And so all these companies are really tightening down the security, which also makes them not want to divulge any information. And also makes it, in some cases, impossible to, because if it's end-to-end encrypted, no one can get access to it. And so you get this tug of war. And what happens is just right there in the middle between them all are just the families and the executors just struggling to figure out how to solve this, how to wrap things up. If you look at the case studies on our website, you'll see lawyers talking about clients who have been fighting for years over intellectual property, or entire estates have been in upheaval over, we know that they had these 10 properties that they were letting out, but they managed it all themselves. They didn't give it to anybody, and they're trying to find those documents. They're trying to find the property documents. They're trying to find all these things. And so really who loses is the family, the loved ones. They're the ones who lose out because the lawyers kind of keep earning their money. The tech companies aren't too bothered because they just stand behind their privacy and security, and if you can get a hold of them at all. And your loved ones are the ones who are suffering and they're in pain. So Australia is not better than UK. If anything, UK is better than Australia because there's a lot more people. So more people are dying, more people are encountering these issues. It's more competitive, and so firms are looking for a way to stand out from their competitors. And that competition really is, what will drive firms to bring in a solution like this. They can offer their clients something more. Law firms really don't like saying to clients, hey, we did your will, but this digital asset clause we put in your will, we actually didn't handle any of that. So can you go find that? And so now firms, are able to go, hey, we give you a will and you also get this digital vault where you can store that important sensitive information, and it'll be given to your executors after you pass away.
We were chatting before we started recording about some of the challenges that law firms, and a lot of companies, to be fair, have in implementing technology and actually, one, identifying the right technology, and two, implementing it in the business in a meaningful and ongoing way. We were saying that, and I hope our listeners aren't too offended by the suggestion that they are time poor, or their time is geared around fee earning, and therefore they struggle to look at sort of the wider opportunities. Something you recognize?
I think it's helpful to kind of take a step back and look at the kind of macro 10,000 foot view of the world we live in today. So, what's been happening over the past few years? Well, 2020 came in and we flew unprecedented into global lockdowns, which meant that with very few exceptions, everybody was working at home. And kind of for the first time, we had this global adoption of technology as people who might have otherwise just died on the heel of pens and paper, suit and tie, and in-person meetings were essentially forced to adapt to technology or not earn an income. And then we emerged from this ordeal and we look around at the world and it simply isn't the same place we left it. The way we work has changed, the way the workplaces work has changed, and the way we communicate is fundamentally shifted too. We had companies trying to get teams back into the office, and the staff were giving them pushback saying, hey, I can actually work from home for fine, thanks, and I really don't love that 1 hour commute in. And it's hard to, if a staff member has been doing that for 2 years, it's hard to put the genie back in the bottle. And then some companies went fully remote. Are you guys fully remote? I think you are.
Yeah, we are 100%. So our teams work from around the UK, actually, to be fair.
Yeah. So you have some companies that are fully remote and then others trying to get everyone back into the office. And simultaneously, we had Bitcoin and NFTs. And now, of course, this whole other new trajectory with AI. That's really been the landscape over the past few years. As you said before, we were talking about why did lawyers struggle to adopt technology? So the answer is kind of like historically they have struggled. And that's for a few reasons. The first being that if they're still working to a hourly billable model, they've got their targets they need to hit. They have to use that time to hit those targets. I've spoken to lawyers whose companies give them 15 minutes a day to not be doing billable time. So if it's coming up to the end of the month and they've got to hit those targets, they're really focused on getting those billable units in. And that goes up the chain. Then you have their bosses trying to do that, their head of departments trying to do that. Everyone's trying to make sure that they hit those targets. Which really, when your time is accounted for like that, it really makes it hard to bring your head up out of water, take a breather and look around and go, could this be more efficient? And in some senses, being more efficient isn't what they want, because kind of like the unspoken secret is if I'm more efficient, then I don't have to fill that time. So there's really no perfect world on that billable model where people can take a step back and look at what's happening and go, can we optimize this to make it more efficient? Some firms have moved off the billable model, and those tend to be the firms that do advance faster because they can step back and go, we've got a flat rate for this, so how can we do more of these? Or to do more of these, we either need more lawyers or we need to be more efficient. It's much easier to put on a software that's going to save us 50% of our time than hire a new person, train them, hope they hit their targets. But the interesting thing was post-COVID, if you zoom in and look at how this affected lawyers in particular, COVID was really the first time in the legal industry where you're forced to adapt or die. And the results are ludicrous. So some firms, not an issue. Just took the laptop home, kept working. I was hearing stories of lawyers sneaking into their office at midnight to grab case files just so they can continue working. I'm sure your listeners can't see this, but you're laughing here. It's I'm sure you would have heard similar stories too. Yeah, because as it turns out, many firms didn't even have a cloud-based document system. And you start to see a pattern here, right? As you go through this. So the firms that had cloud-based were fine. They were able to transition with relatively little disruption. The ones that didn't, oh no, all of a sudden they're investing tens of thousands of dollars to try to be able to get their staff to work from home. What does it involve to work from home? Well, you need to be able to communicate with your team. You need to be able to communicate with clients. You need to be able to perform research. You need to be able to draft documents. And if you're still doing billable hours, you need to be able to track time. And so through that process, everyone eventually managed to work remotely. And all of a sudden, COVID ends. What happens? You've kind of taken these steps down a path that kind of for the first time you were forced to because you couldn't do those billable hours. And firms kind of want to go back. But what's interesting is now the client expectation has changed, because when you change the way you communicate with people, their expectations on that platform are different. So we have a term for this in software development called UI or UX convention, which means that, if I said to you, David, here's an app, you would expect there to be a settings page. You would expect your delete my account to be under the settings page. But all of a sudden, you see firms dealing with their clients online. And now they have all these different expectations around how they should be able to deal with their clients online. Because while the legal industry had been really slow, the rest of the world hadn't. And so what we see now is this playing out really interesting ways, with clients now being the driving force to push firms to adapt and include technology, because they kind of expect, I should be able to chat with you online. I should be able to review my documents online. I should be able to, like with any other industry, kind of work asynchronously, complete something online, start my will online, whatever it is. I'd be interested to hear your perspective. Have you found, like post-COVID, that firms are adopting tech more quickly?
I was about to respond and say I absolutely recognize the point you're making around speed massively. So even emails, take that as a very simple example. We were all sat in front of our computers, weren't we, for 2 years, and we were able to respond pretty quickly to inquiries and queries and that kind of thing. Suddenly now, and I don't know whether you particularly find this, if you haven't responded to somebody within, I don't know, 12, perhaps 24 hours, there's an expectation that actually there's a delay in the response almost. And we're British, so we're apologetic about it. Oh, I'm sorry I didn't come back to you so quickly. That's something that I absolutely recognize. In terms of your question about whether firms are adopting tech, yeah, they are. I mean, again, we're seeing that over here. Probably not as quick as the tech providers might like, but it is happening. And I take your point about it being in part driven by consumers as well. And that sort of leads me on to, I wrote down as you were chatting, you talked about families losing out. One of the issues, particularly with some of the technologies, is that families lose out. What is it that you are seeing that families want from something like BePrepared?
There's a few elements. The first one is kind of rather simply, they want to be able to review their matters online. They want to be able to, like, in a secure place, be able to read their documents. They don't like searching their emails for the last draft. Which draft was it? I've got 18 emails from you with updated Word documents, trying to find the correct document. The second is, today, pretty much everyone has a phone or a tablet or a computer. And almost everybody's aware that there's important information on there. If you put aside, like, financial value of any assets you might hold, there's important stuff in there that helps people. The clients are bringing it up. They're going, what do I do with my phone and my computer? Can my family sell it? Well, unless your phone's unlocked when you pass away, that's now just a brick. You can't resell that repurpose. That's a $2,000 phone. So they're wanting to be able to work in a modern fashion with their firms. I think about this from intake through to completion, because it's not just about BePrepared, it's about the entire experience. What did you used to do? If you needed a lawyer, you'd probably go on their website. There wouldn't be much there. You'd call them up and book an appointment. And now, during COVID, like, we're all on our computers all the time. Like you said, you'd be open 18 tabs for different law firms. And like, oh, look, this one I can chat to straight away in the chat bubble, or this one I can begin my will with the online form. I want to do that. I don't want to have to go in and, like, find time in my calendar and go sit across from someone and talk about my stuff. So it's from that stage all the way through to the end where they have this central repository of all their most important information, all their legal matters, all their legal documents, property documents, that's just in one place, that's maintained by their advisors. BePrepared lets you connect to other advisors. So what we see a lot is firms connecting your financial planner or your accountant and kind of having this single repository for all your important stuff. The expectation from the client when they come to a firm online is that it should be on par or equivalent with everything else you do online. You can order food to your house via Uber. You can order a car there straight away. You can click anything online and have it delivered to your house in a week. You can talk with your friends, your colleagues instantly. You kind of expect the same from your advisors. And I think that's what people are looking for. They're looking for security, but they're also looking for being able to engage with things, like, on their own time and their own schedule in a format that they're used to.
The listeners will love the analogy with Amazon. I mean, crikey, we have that over in the UK at the moment about, well, if you can do it on Amazon, like you say, you can get food ordered in, you must be able to do it with the law. It's a very different thing, I think, and we have to protect. I think we have to protect the law a little bit from some of those expectations because it is a much more complicated beast. What then do you think that estate administration looks like in the future? We're using technology, but it still feels as though we're very bound by the limitations of the law, for example, and just simple limitations of what we can and can't do with a will or with an LPA.
Well, again, if we look at the macro trend of what's happening, well, everything's going digital. Here in Australia now, our driver's licenses are digital. I know in America, all their property documents are now digital. Yeah, that's happening also in part of Australia as well. Everything somewhat inevitably is moving towards that digital realm. And so when you look at the future of estate administration, it really just comes down to, can you collate and collect the digital records of everything your client has in order to administer them effectively? You're correct in that we're bound by the law. The law written in before computers are even a blip on our radar assumed, a good, like you said, that's kind of the start of the podcast, wet signature. They assumed that two witnesses would stand in a room and sign the document, and that was the best way to make sure that it was a valid will. Today, technology allows us to not only make sure that's a valid will, but it's actually the same will, because we can hash that will and we can tell you if anything has changed on that, whether a pixel has been edited, whether something's changed at all. You can know we're all looking at the same document. The future of wills and estates will really just be digital wills and digital estates. That's somewhat inevitable. I know STEP's pushing really hard for reforms around e-signing and e-witnessing to make the legal industry more modern. That will take time. And in the end, what we kind of really have to think about is, in the meantime, how do we make the process easier for the families, for the loved ones, but also for the lawyers? Because if you're sitting there and you know your client has $3 million worth of Bitcoin in a PC that you can't access, but that's a life-changing amount of money for their benefactors, what do you do? If you know that someone had a social media page with 2 million followers that generates $20K per month, but you can't access it. But again, that could be someone's college fund. That could be a new house. What do you do? I think these are important questions to ask. And luckily we do have bodies like STEP who are really trying to push the envelope and get the law to change.
There is a very real and legitimate concern about veracity, about capacity, particularly around digital. Is that a concern that you address specifically with your product as well, that you can verify that the person who sets it up is who they say they are, that the access provided to it is who needs the access?
Our platform is actually built to military grade specifications. So it's stronger than any kind of bank platform that you would use. That's going to become the norm as we move forward. We're seeing this year in the cybersecurity space, many, many, many more companies requiring SOC 2 certifications and ISO certifications, even from simple applications, because of all of the data breaches that are occurring day by day. So if you're a tech company and you're listening to this, you need to be on top of that. You need to be able to prove that you have the wherewithal to have, and the grit and the robustness in your platform to make advisors and citizens feel comfortable in storing their data with you.
What I'm trying to get at, and I'm not sure I'm articulating it very well here, Dylan, is that how do we verify that the information that is in the platform should be there, that it hasn't been infiltrated in some way, in the same way that when we were doing online video witnessing or online video meetings, we're moving the camera around the room to make sure that there's not somebody stood over our shoulder saying, you need to do this. How do we make sure that technology like this isn't being repurposed in the wrong way?
That is in part why we are a law firm platform as opposed to selling to members of the public. Our platform is only available through law firms, and it's in conjunction with those law firms that we can ensure the integrity of the data and the clients that are being placed in there. So your lawyer has to generate the encryption keys for your vault. They have to verify your identity. And then those go to you where you can place information in there. And then on your end, you have a whole bunch of other user controls, verifications required for you to interact with that vault and to make sure that it's only you interacting with that vault, not someone else you know. This is also why we don't have couples vaults. Couples can't have a shared vault. It is an individual vault used by one person in conjunction with their firm to make sure that the right information is put in there. And so when you die, both the client and the firm have the comfort and confidence that those assets will be distributed efficiently and effectively by the right people to the right people.
I think it's fair to say from some of the conversation even today that there are challenges that are cross-jurisdictional that affect Australia, America, the UK, and lots of other countries. And one of the biggest challenges is this digital assets issue. And as I say, Law Commission in England and Wales are looking at it, but it's a wider piece where firms have got to get to grips with advising and being in a position to advise on how to deal with and how to manage digital assets. So it's been great to have you on the podcast, Dylan, to share your insight. Thanks very much indeed.
Thank you so much for having me.
The Today's Wills and Probate podcast is available on your preferred podcast provider. It's also available on today'swillsandprobate.co.uk. My thanks to Dylan. Thank you as ever for listening, and we'll see you again soon.
You're listening to the Today's Wills and Probate podcast, one of the leading sources of information for the wills and probate sector. Don't forget to subscribe and sign up to our free newsletter at today'swillsandprobate.co.uk and follow us on LinkedIn and Twitter.
Hello and welcome to the first ever Today's Wills and Probate podcast. My name's Tom Lees, Director of Engagement at the publication, and over the next few months we're going to be bringing you some fantastic guests as we talk a host of topics such as improving the probate process, technology, cultural and business challenges in what will hopefully be a post-pandemic world, and speak to some of the industry's leading innovators. The podcast will be available through all your main podcast providers such as Google, Apple and Spotify. Please subscribe so that our first episode due in the next few weeks is ready and in your feed. We'd love you to share that with friends and colleagues alike across the sector, and we're going to be talking to Exizent, a technology business in Scotland who are making big waves when it comes to better connecting those involved in the probate process. Hopefully, you're as excited about the project as we are, and we look forward to you listening. If you'd like to get involved or have any questions for us, please email press@today'swillsandprobate.co.uk. Bye for now,